is that might makes right. Hence, the first foundational finger is that it has been said that the law is the ground floor for ethics, and that politics at its best is guided by ethical concerns. Our second foundational finger is that there is no separation between the law and politics in all of their forms, and how a person or a community answers the eternal moral questions of, one, who tells you who you are, and two, to whom are you responsible? To whom do you owe? Law and politics are how we answer these two questions as individuals, as a community, and as a nation. The third moral claim we affirm through our gathering this evening is twofold. Number one, words create world. Now and then. So by being here and hearing the information being presented, we are affirming that words create worlds, and that we are committed to acting with courage. The fourth finger of our moral foundational hand answers the question, by what mechanism shall a moral and ethical life be taught? We affirm that no one interprets their lives on their own. And hence, there is no such thing as a privatized morality. No one is a privatized morality. No one is intelligent or wise enough to develop a moral way of life on their own, out of whole cloth. We need a community for that. We need to tap into a tradition or a story for support in our moral hand by which the weight of this event has been grasped comes from an age-old African wisdom, which says it is more important to be a loving ancestor than a dutiful descendant. None of us will get out of life alive. So with that in mind, our presence here this afternoon is a moral expression of the fact that we want to be ancestors that our descendants and others can look to as an example of how we are not necessarily made to think, but we are made to love. And the mark of being human is not reason, but rather our capacity to show love and be loved, because God is love. The five-fingered moral foundation of our time together has been laid. So let us now rest in its grasp as we get the information we have come here to get.
Good afternoon. So this afternoon, I first of all want to thank Judge Pitcher and the pastor and other organizers for the opportunity to speak to you all today as a member of this panel. I have been charged with the task of starting the panel with, first of all, a historical or a context to talk about the current situation of our government and its structure, to give a little background information, and then get into some of the more recent decisions from this 24-25 term of the United States Supreme Court. And I'm going to focus on the First Amendment. Specifically, I'm going to talk about the Establishment Clause. And my colleague, Professor Thrower, will segue from there into the Free Exercise Clause and substantive due process. So let me go ahead and get started. First of all, I want to talk a little bit about the structure of our federal government, because it is important for us to understand the landscape that we now find ourselves in. Our federal government is set up with three branches of government. Certainly, we all learned that in elementary school. The executive branch, the president being the head of that branch, the Congress, which has two houses, the Senate and the representatives, as well as the judicial branch, which is has at its tier the United States Supreme Court. The United States Supreme Court being the final arbiter of what the law is. So the Supreme Court interprets the Constitution and laws passed by Congress, and the president is supposed to carry out those laws. Now, it is also important for us to understand the unique position that we are compared to recent years post the civil rights era, in the sense that all three branches of the federal government at this point in time are controlled by one party. In recent years, the federal government typically had various representations in terms of the Republican Party and the Democratic Party across various presidencies. If you think about, for example, the Obama administration, the executive branch primarily obviously was in the hands of a Democrat. The Supreme Court had justices that were essentially equally divided, Republican appointed, Democrat appointed, oftentimes 4-4, with a justice that might swing, a moderate justice who might swing back and forth as far as decision making between the conservatives and the more liberals. In terms of Congress, during the Obama years, we saw Congress at some points in time being majority Democratic, whereas other times we saw a Republican-led Congress, which is why we saw Obama being unable to confirm as the Supreme Court justice during the last year of his term of office. And that's particularly relevant, tied to the current composition of the court. It matters to have both both political parties represented as leaders or at the head of the various branches, because it creates a climate such that the checks and balances are used, that have been put in place such that no one individual or no one branch of government thinks it all powerful, right? Like it or not, President Obama had the check of Congress reminding him that they could balance the power. Similarly, during the first term of the current president, he also experienced a situation where sometimes Republicans were in control of Congress, other times the Democratic Party was in control, which is why we saw the Democratic Party being able to address the changes that were made in the law after Dobbs, as far as protecting the right to marry for all individuals. Congress came back and put that protection in place based upon some things that were said by one of the justices in the Dobbs case. And without going too much into that, we now, though, are in a situation where both Congress and the court are essentially run by the Republican Party. And as we know, the executive branch is headed by the Republican Party, such that we are seeing now decisions that are being made by the executive branch, specifically that many know and understand not to be within his authority, but there is concern that Congress is not addressing his usurpation of their authority and other branches of government's authority. And similarly, we see the Supreme Court, which is now a 6-3 majority Republican appointed court, seem to also be in lockstep. And so I want to now then talk a little bit about the court specifically in terms of how the court in its recent decisions, starting first of all with the trilogy of free exercise cases, and then leading into the current term's decisions. So looking at the First Amendment, first of all, as we know, the First Amendment has two religious protections, the Establishment Clause and the Free Exercise Clause. These clauses are supposed to work together for the purpose of protecting our rights to religious freedom. With the Free Exercise Clause, we have the freedom to exercise our religious beliefs without fear of punishment by the government. And on the other side of that, the Establishment Clause is designed to keep the government, whether it be state or local or even federal government, from trying to coerce or force us into a particular kind of religious practice or belief. And what is of particular concern in recent decision-making with this 6-3 Republican-appointed majority is that the court seems to be whittling away at the Establishment Clause. And while many of us as Christians might believe that it is a good thing to have religion being recognized as being just as protected in decision-making of the government, in the award of benefits and services, as I will talk about shortly, it is this whittling away of the Establishment Clause is something that we as Christians should be concerned about. So first of all, the free exercise trilogy of cases. These cases, beginning with a 2017 case leading up to pre-Kennedy, which also was in 2022, the court reached decisions that essentially now prohibit a state or local government from holding a service back from a religious organization or a benefit, or excluding a religious organization from a benefit based upon its concern about complying with the Establishment Clause. Again, the Establishment Clause historically was a situation such that the government in its decision-making had to not favor religion, had to not entangle itself with religious activities, and such that there is a wall of separation. With this trilogy of cases, the court repeatedly told state and local governments that if you are going to provide a benefit or service to private individuals or to private organizations, you cannot exclude religious organizations. So for example, in Trinity Lutheran, we saw the court determine that denying grants for resurfacing of daycare facility, playgrounds for children, could not be, applications from religious daycares could not be denied if they were being granted for secular daycares. So essentially, the same grants that were allowed for free resurfacing had to be given to religious organizations. The reason that the local, state, and local governments were denying this application was because it did not want to involve itself in making decisions that impacted religious organizations. Similarly, we saw in the Espinoza case, the court held that a state scholarship program that allowed for the state to provide funds for children to attend private schools, whether it because their school system did not have public schools or the public schools were underperforming, that the local governments had to also include religious private schools in those scholarship programs. Again, historically, the court had previously held repeatedly that the government funds could not be used to get an education in a religious institution, largely because of concern about intertwining the government with decisions tied to religious institutions. And finally, the Carson versus Macon case from Maine involved, again, a situation of a tuition assistance program that allowed students that did not have access to good public education to go to private schools. And again, the court said that the tuition assistance programs had to also include religious schools as well. So essentially, this line of cases amounts to the court saying that whereas before the Establishment Clause was justification to not grant certain benefits to religious organizations, that now those organizations have access to the benefits. And at first thought, we think, okay, that's great. Kids can go get a Christian education. Kids can feel that they're going to be treated the same. All these programs are going to be open to everyone. However, of concern, these decisions became more of a concern when we look at the Kennedy case, which was a case from 2022. Prior to Kennedy, as government employees are the government, right? And so I work for the state of Louisiana. I'm a Christian in my private life. I'm the government in my public life. Kennedy involved a public school football coach who was also a Christian. Generally speaking, prior to the Kennedy decision, football coach cannot indoctrinate his players. He cannot force his players to participate in religious observances such as prayers, etc. Kennedy ultimately gets terminated because he continues to have prayers and sues because of his termination, and the case comes up to the Supreme Court. The Supreme Court determines that at the time of his prayer, and I don't want to take too much time, but this case, I ask everybody to please look at this case, because this case is one of those hand-picked cases, and the decision is one that it was clear that his lawyers advised him to change his behavior in certain ways that would make his case winnable for him. Long story short, by the time of his termination, he had changed the midfield prayer post-game such that participation was voluntary. So ultimately, the court determined that, one, he was not a government employee at the time of the prayer. He was exercising his free exercise protections to thank the Lord for giving him the victory on the football field during the game. And if kids decided to come and participate in that prayer, that was purely voluntary. There was no coercion, nothing involved. So they were certainly free to do that. In addition to that decision, the court also overturned the Lemon test. The Lemon test was the analysis that had been used in deciding if there is an establishment clause problem. So now we no longer have that analysis that says it's problematic for the government to mix itself up with church business. We no longer have the entanglement issue. Now we look at all cases under strict scrutiny when religion is being treated differently. So today, in 2025, we have decisions from the court. In these decisions, I apologize for flipping all these pages. We see one in particular of concern. The first decision is a unanimous decision, and it is the decision that we expect to see after Kennedy, in the sense that a religious organization was providing services to the community and sought, because of that, to be exempt from having to pay unemployment taxes for its employees, which is what typically happens for religious organizations. The request for the exemption was denied because the organization providing the services, while led by the Catholic Church, was a subsidiary that did not require its employees to be Catholic, and services were not required to go to Catholic parishioners. It could go to anybody. The court said it did not matter that this was a part of the Catholic Church, such that they should be entitled to that exemption, which would have been a significant departure from the way the court would have construed this. And again, I would always recommend and strongly encourage people to read the dissents, because the dissents are important. But this was a unanimous decision, again, post-Kennedy. I then turned to the Oklahoma statewide charter school board versus Drummond case, which is not a unanimous decision. This decision is particularly relevant for a number of reasons. First of all, the court rendered this decision in a split down the middle, 4-4. Why 4-4 and not 4-5? Justice Barrett did not participate in the decision, such that the conservative justices, minus Justice Roberts, who oftentimes sides with some of the more liberal justices, sometimes, even though he is a Republican appointed justice, sided with the 3 liberal justices in the decision and wrote a very important dissent. I'm sorry, that They did not dissent. They dissented. His dissent bears out in the Mahmoud case. I apologize for that. It was actually no opinion. The court affirmed the decision of the Oklahoma State Supreme Court without decision, but it was split down the middle. This case involved a charter school system in the state of Oklahoma. As we know, similar to Louisiana, charter schools are treated as public schools, and they are run by private organizations. Traditionally, those organizations are not affiliated with any religion. In fact, the contracts and the law in the state of Oklahoma specifically require that it not be religious organizations. Why? Because charter schools are public schools. The contract that was set in place specifically for this new school that was approved by the charter school board in Oklahoma eliminated that requirement, such that this religious school could be a public charter school that stated in its charter it would teach and indoctrinate its students the Catholic traditions and doctrine. So the Oklahoma Supreme Court struck down the grant of this charter by the charter school board. And the charter school board took the case up to the United States Supreme Court, and the Supreme Court affirmed the decision. But again, what is concerning about the Supreme Court's affirming this decision is that 4 people disagreed. 4 people on the court felt that this religious school should be granted a charter to run a public school that would teach and indoctrinate its students into the indoctrination of the Catholic Church. Why does that matter? Because we no longer have, we're seeing slowly but surely, the court is whittling away the protections that were designed under the Establishment Clause. And what does that mean? It means that states can no longer say that religion is being treated differently because we don't want to mix ourselves up in private church business, or we don't want to treat people differently, ultimately, or we don't want to legalize singling people out in a way that some current Christian teachings do. And that, I think, is a way to transition to one of the cases that my colleague, Professor Thrower, is going to talk about in terms of how the court is slowly but surely whittling away at the Establishment Clause, in the sense that once there is no prohibition against the government telling you what religion you are getting itself involved in religion, we open the door to a possible state-sanctioned religion. And that may seem drastic, but there are many things that we see going on right now that are not, make it seem actually a possibility that could happen, particularly in light of the case that, one of the cases that, that's me, I feel like I'm rushing, but I'm sorry. One of the cases that Professor Thrower is going to talk about, specifically the Mahmoud case, explains, I believe, how ultimately, I think the prayer pointed out that if one of us is treated, mistreated, or discriminated against, we all are opening ourselves up to that happening to us. And if it can happen to people in, for example, the LGBTQ community, it can happen to us, and there won't be anything we'll be able to do about it at that point if we continue to allow this whittling away to occur. Thank you.
Good afternoon to everyone. My name is Professor Jason Thrower. I'm assistant professor of law at Southern University Law Center. And before I get into my discussion today, I want to take an opportunity to first thank Dr. Richardson and Wesley United Methodist Church for hosting this important event. I thank you all for coming out, of course, to hear what we have to share. I thank Judge Pitcher for the invitation to be a part of such an esteemed panel. And I thank my colleagues for sharing space with me to discuss important issues about the recent U.S. Supreme Court cases generally, and several cases specifically, and their impact on communities of color. Before I get into speaking about the specific cases, I want to, as I often do with my students, and forgive me, I'll get a little bit more comfortable on this lectern. I want to lay the foundation of what my discussion will entail as it relates to this notion or this concept of fundamental rights and or individual liberties. A fundamental right is a right that is considered or defined as an individual liberty that is deemed so important that generally the government cannot infringe upon this right unless the infringement is necessary, meaning it's narrowly tailored or drawn or drafted very narrowly in order to achieve a compelling governmental interest. Now, rights that are contained in the first 8 amendments of the U.S. Constitution, which you will recall in your either elementary civics classes or high school government classes, or for the lawyers in the House, in your constitutional law classes, commonly known as the Bill of Rights. These rights are generally considered fundamental. Rights like the First Amendment freedom of religion, which Vice Chancellor Ramsey discussed. Rights like the freedom of the press, the freedom of expression or speech. The Second Amendment right to bear arms, the Sixth Amendment right to a speedy trial and the assistance of counsel. These are well-known rights that are captured and expressly provided for in the Constitution. But importantly, a substantial number of rights are not recognized, or that have been recognized rather, but as fundamental, but are not mentioned in the text of the Constitution exist as well. Rights like the autonomy or privacy in making decisions such as who one may marry, whether you would like to bear a child, how you can raise your child, whom a person may engage in sexual activity with. These types of rights that have been recognized over time are not expressly or explicitly provided for in the text of the Constitution, which creates several questions in the minds of common law scholars and everyday citizens alike. First, where do these fundamental rights or these individual liberties that are not written in the text of the Constitution come from? And second, how should the court decide whether a liberty should be regarded as a fundamental right? Now, the answer to the first question requires a significant legal history lesson, which time doesn't allow us to consider today. But suffice it to say that traditionally the court has recognized these rights under the Due Process Clause of the 14th Amendment, which provides that no state shall deprive any person of life, liberty, or property without due process of law. The 14th Amendment is often combined with language from the 9th Amendment, which indicates that certain rights that we possess as American citizens are not necessarily mentioned in the text of the Constitution. The 9th Amendment reads that the enumeration of in the Constitution of certain rights shall not be construed to disparage others retained by the people. And so you have this amalgamation, if you will, of the 14th Amendment Due Process Clause and the 9th Amendment that provides for this a safe space, if you will, that rights that are not expressly provided for in the Constitution nonetheless have been deemed or recognized to exist by the court. Now, the answer to the second question has largely been decided based upon how the Constitution is interpreted by the justices that sit on the court. Painting with a very broad brush, and Vice Chancellor Ramsey noted this in her discussion as well, generally speaking, justices who were appointed by conservative presidents, read Republican presidents, tend to interpret the Constitution conservatively or in a way that narrowly limits individual liberties in the way that they read the Constitution. In our current court, Chief Justice Roberts, who was a George W. Bush appointee, or whom, for the purposes of our conversation today, I'll refer to as Bush II. Justice Thomas was a Bush I appointee. Justice Alito, a Bush II appointee. Justice Gorsuch, a Trump appointee. Justice Kavanaugh and Justice Comey Barrett, also Trump appointees. These justices round out the 6 conservative justices that, again, Vice Chancellor Ramsey referred to. Conversely, justices that were appointed by more liberal or conservative executives, or presidents, read Democratic presidents, tend to interpret the Constitution more broadly or more liberally. Justices like Justice Sotomayor, Justice Kagan, who were both President Obama appointees, and Justice Ketanji Brown Jackson, the most recent appointee who was appointed by President Biden. Which brings us back to the case that Vice Chancellor Ramsey mentioned, Mahmoud versus Taylor. Now, I will forewarn you that admittedly, my discussion, or the cases that I am slated to discuss, will contain some of the more controversial decisions by the court, particularly as it relates to speaking in the house of the Lord. I guess that's the consequences of being a junior professor on the panel. And I'm fine with that. Nevertheless, as the son of a pastor and as an executive pastor myself, I'm very well versed in the order of the house, and I know how to deal with the subject matter. But if we run from rather than deal with issues, then they will not be resolved. So is everybody ready to hop in with me? So let's talk about Mahmoud. Recall these justices and who they were appointed by, because I'll bring them up in terms of who authored the opinions. Mahmoud was decided June 27th of this year and authored by one Justice Samuel Alito. In Mahmoud, the court ruled in favor of parents who sought to opt their children out of certain classroom materials, specifically LGBTQ+ inclusive storybooks, based on the parents' religious objections to the subject matter of the books. The case centered on this conflict between the school district's policy in the Montgomery County Public Schools system in Maryland and the parents' desire to control their children's exposure to content that they deemed religiously objectionable. The parents objected to these books on religious grounds, specifically citing their religion in these objections. And there were numerous parents who cited their objections from various religious backgrounds: Ukrainian Orthodox, Catholic, and the Muslim faith. And Vice Chancellor Ramsey and I were speaking in advance of the session today, and we said, I wonder if the court intentionally highlighted faiths that were outside of the Christian faith as a facade, if you will, to give cover to the decision that they would render. I'll pose that for your own perusal. Now, in Mahmoud, initially the school district accommodated the parents' objections by allowing the parents to opt their children out of the lessons featuring these books, but later the school board reversed policy, citing administrative burdens. It would be too burdensome on the school district to allow for so many opt-outs virtually that they would essentially have to offer a different curriculum. And so, because of this, the school board reversed course. The parents filed a suit And they claimed that the school's policy violated their First Amendment rights to the free exercise of their religion. Now, keep in mind that my discussion is focusing on this notion of individual liberties and substantive due process. Different, if you will, from the rights that were outlined under Vice Chancellor Ramsey's discussion under the First Amendment. And actually, Mahmoud is an intersection of principles captured in the First Amendment as well as individual liberties in the 14th Amendment. I point that out because the majority held that this particular curriculum imposed a substantial burden on the religious exercise of these parents by presenting normative messages about gender and sexuality that contradicted the parents' religious teachings. The court emphasized that mere exposure to conflicting ideas, when combined with the lack of opt-out options and teacher reinforcement, constituted coercion. There was a case that was cited in Mahmoud that the plaintiffs heavily relied on, a case by the name of Wisconsin versus Yoder, which is a 1972 Supreme Court decision that was a rare unanimous decision by the court that recognized parents' rights to direct their children's religious upbringing and found that compulsory education laws could burden religious exercise. Now, the primary right here is, for the purpose of my discussion, is the right of parents to raise their children as they see fit. And the carve out of the capture, if you will, that provides for that safety net in Mahmoud was the free exercise of their religion. Justice Thomas offered a concurrence to Justice Alito's and the majority's opinion, arguing that the policy represented ideological coercion and lacked historical precedent. He emphasized the primacy of parental rights over state educational mandates. The dissents, however, saw it a different way. Justices Sotomayor, joined by Justice Kagan and Jackson, again, these more progressive or liberal justices, who warned that the ruling grants power to parents to veto the public school curriculum of their districts and undermine the democratic governance of education, and could lead to widespread opt-outs from lessons on evolution, slavery, and civil rights.
Yes.
This could be a particular problem to communities of color. And so, what are some concerns that Mahmoud raises about the impact on communities of color? Certainly, first, the concerns about inclusivity. Some argue that the decision disproportionately harms students from marginalized backgrounds. Obviously, those students from LGBTQ backgrounds, but particularly children of color who may be LGBTQ, by enabling curricular censorship that erases diverse experiences. And there's also this notion of this expansion of opt-out rights for parents that sets a precedent for broader religious opt-outs from public school instruction, potentially affecting, again, lessons on race, gender, history, and science. Now, this dovetails with something that may be familiar to you. Conservative agendas like in states like Florida and here in Louisiana, and local governments like in our neighboring Livingston Parish that seek to remove certain books from libraries and schools that deal with our country's history on race and slavery. This is one of the unintended consequences of Mahmoud that particularly could manifest. In a similar ruling, related tangentially at least from this, the most recent term of the court, was an opinion handed down by the name of U.S. versus Scametti. And Scametti was authored by Chief Justice Roberts and was a case that challenged the constitutionality of a Tennessee law that banned gender-affirming medical care, specifically puberty blockers and hormone therapy for transgender minors. I told you, I've got the controversial stuff for the House, bear with me. Exceptions under this law existed for medical conditions like precocious puberty or congenital defects. A lawsuit was filed by parents of transgender minors a healthcare provider and the U.S. government even joined in, at the time headed by President Biden, arguing that the law in Tennessee violated the Equal Protection Clause under the 14th Amendment. Now, although the Equal Protection Clause is a part of the 14th Amendment, it is much different. It's a much different argument than the one that we just spoke of, the substantive due process argument that was articulated in Mahmoud. The argument for an equal protection issue typically says that the government has chosen to discriminate based on different classes of individuals rather than the existence of a fundamental right or an individual liberty. It's important that Skrmetti differed in its argument because the parents in Skrmetti did not assert an argument under the substantive due process or suggesting that they had the right to raise their children as they desired under the 14th Amendment Substantive Due Process Clause. As you would imagine, the court upheld Tennessee's ban in a 6-3 decision along ideological lines, finding that the law did not discriminate based on sex or transgender status, which would require overcoming a higher standard or burden to be upheld. Rather, the law discriminated on the basis of age and medical diagnosis. And when you talk about distinctions or classifications like age and medical diagnoses, those types of classifications require a lower burden or a lower standard in order to be upheld. The government is giving great deference to passing laws that only meet what's known as a rational basis review. And so what the court effectively did was took the notion of transgenderism and this question of transgenderism being based on sex or gender, which would require a higher burden or higher level review, and brought it down to a lower level review. In other words, they made it easier for the Tennessee law to be upheld. Now, what could possibly be the impact on communities of color for a holding like this? The decision, again, disproportionately affects transgender youth, particularly those in Black and indigenous communities of color who already faced barriers to health care access. Some warn that a ruling of this type emboldens anti-trans legislation and could lead to the criminalization of parents and providers, especially in conservative states like Louisiana. Now, you may or may not have a transgender child or no transgender children, but I can assure you that someone you know does if you don't. And so this definitely directly impacts them. That's my 5-minute mark, so let me speed up. Most importantly, the future challenges for the holding in Skrmetti could shift toward these due process claims, such as one that parents can make parental or make direct medical care decisions for their children. However, because this issue essentially relies on state constitutional protections, that may involve some conflict. The decision also could influence litigation around reproductive rights, bodily autonomy, as well as access to health care for marginalized groups. And this notion of reproductive rights, bodily autonomy, was a major issue several years ago with the court's ruling in Dobbs. Dobbs, handed down in 2022 and authored by Justice Alito, again, considered a very marked shift in the way that the court interpreted constitutional law as related to fundamental and reproductive rights. Dobbs very quickly dealt with or spoke to Mississippi's Gestational Age Act, which banned most abortions after 15 weeks of pregnancy. The court, as you all know, upheld the law overturning Roe versus Wade and Planned Parenthood versus Casey, ruling that the Constitution does not confer a right of abortion. Now, I take you back to our initial discussion. Well, how does one find within the Constitution protection for rights which may not be written there? Well, the court in Dobbs spoke to that in rendering its opinion. The majority, again, the conservative majority of Alito, Thomas, Gorsuch, Kavanaugh, and Barrett rejected this notion that abortion is a fundamental right under the Substantive Due Process Clause, emphasizing that the Constitution makes no explicit or implicit reference at all to abortion. The Due Process Clause, which had been the foundation for Roe and Casey, the court held did not protect abortion because the right was not deeply rooted in the nation's history and tradition. Importantly was the concurrence from Dobbs that was authored by Justice Clarence Thomas, which called for reconsideration of all substantive due process precedents, including those protecting rights to contraception, same-sex intimacy, and same-sex marriage. His concurrence explicitly invited challenges to each of these precedents, essentially drawing a line in the sand, suggesting that substantive due process rights or rights that may not be written in the body of the Constitution should not be recognized at all. How does this impact communities of color? Well, aside from destabilizing the substantive due process doctrine and raising concerns about the future of rights like same-sex marriage or contraception or private intimacy, the Dobbs had a disproportionate effect on communities of color because abortion regulation returned to the states, 16 states in 2024, having severely restricted bans on abortion. Black and American Indian and Alaska Native women are more likely to live in states that ban or severely limit abortion. Uninsured rates are significantly higher among women of color in these states, limiting access to reproductive care, and maternal mortality rates are already higher among Black and Native women, and abortion restrictions are expected to worsen these disparities. Now, in the interest of time, I'll talk about one last one, and I will transition to Professor Diamond, and that is this birthright citizenship case. Of course, immigration being a very hot button issue within our government. And the case of Trump versus Casa de Maryland, which was authored by Justice Barrett, involved a challenge to President Trump's executive order, which aimed to restrict birthright citizenship. You will recall at the beginning of our year, 2025, a plethora of executive orders were issued by this administration, one of which sought to essentially redefine birthright citizenship by excluding individuals born in the U.S. to certain categories of immigrant parents, which was contrary to the traditional interpretation of the 14th Amendment Citizenship Clause. Several district courts considered the issue and issued rulings that included nationwide injunctions, meaning that they blocked the enforcement of this executive order nationwide, even though the request for the injunction may have been filed locally. And so this particular issue, although it spoke to this birthright citizenship concern, was another opinion that was passed along ideological lines. In a 6-3 decision, the court ruled that federal districts likely exceeded their power and their authority by issuing universal injunctions that went beyond providing relief to the plaintiffs that were named in the case. Importantly, in Trump versus Maryland, the court did not address the constitutionality of the executive order itself or the merits of the birthright citizenship question. The decision focused squarely on the procedural mechanism, which was the scope of the injunctions. What impact does this ruling have on communities of color? This decision has significant implications for our immigrant brothers and sisters. We talked about the birthright citizenship issue and being a foundational protection for children born to immigrant parents. This ruling creates this uncertainty and fear among these communities. By limiting the court's ability to issue nationwide relief, the ruling raises barriers to systemic justice, requiring individuals to sue separately. Particularly, this decision restricts a very important judicial tool, that of the universal injunction that has historically been used to protect civil rights. Critically important to people of color, especially in the immigration and the racial justice context. And so, as I transition to Professor Diamond, I will leave the cliffhanger there with you to anchor in on this notion of civil rights. And Professor Diamond will likely talk about a very important case, the Ames case, that differed or essentially pivoted on the way that the court, in a unanimous decision, considered civil rights in an employment context. Professor Diamond.
I'm going to set my stopwatch so that I can be sure to stop on time. Well, first, I want to echo my fellow panelists and thank Chancellor Pitcher, Judge Pitcher, and Pastor Richardson for bringing me back here to Wesley. You may not know this, Pastor, but there was a time when I worshiped here at Wesley, and I felt at home, and I still feel at home. So thank you for bringing me back home. Now, my job here today, I'm going to talk about two things in the main, and if I have time, I'm going to try to put these things into a larger context. Now, first, I want to talk about a subject that has been the subject of much weeping and gnashing of teeth in the Trump administration. I want to talk about affirmative action. And I want to start with a case not from this last term, but from the one before that, from 2023, Students for Fair Admissions versus Harvard. Now, that is a case which ended affirmative action as we know it, certainly in the educational sphere and perhaps in all spheres altogether. It ended affirmative action as we knew it since the University of California versus Bakke. Now, that case was decided in 1978, and it was decided in an odd fashion because there was no majority opinion. There were 4 judges who thought that affirmative action was just horrible stuff and you couldn't do it anytime for any reason. There were 4 justices who thought that affirmative action was good stuff, thank you very much. And there was one, only one, Justice Powell, in the middle, whose separate opinion became, for all practical purposes, the law. Justice Powell condemned racial quotas. You couldn't, as was done in that case, reserve 15 seats for racial minorities. You couldn't have racial quotas, but he approved of diversity in the educational sphere as a compelling governmental interest. Now, why is this important? Professor Thrower spoke about this a little. Because racial discrimination is to be condemned under our Equal Protection Clause unless there is not simply a rational reason, not even an important reason, but a compelling reason. Unless there is a compelling, you can read that as really, really important governmental reason. And unless the discriminatory governmental act, unless the racial preference in this case was narrowly tailored to fulfill the governmental interest fully, and not one whit beyond that. That was the law in education, and that was in fact a law, that in fact was a legal standard that we could use in governmental hiring and in governmental contracting. And that was so until 1989 with Croson versus City of Richmond. That was a case involving the city of Richmond, which had an affirmative action program in governmental contracting. The court there emphasized that racial preferences in contracting for minorities are acts of racial discrimination. And it emphasized strict scrutiny as the standard. Remember what that is: compelling governmental interest and narrow tailoring, right? Now, when I read City of Richmond versus Croson back in 1989, literally I almost cried because I could see the end of affirmative action coming. What I did not properly appreciate is the extent to which good lawyering would save affirmative action. If affirmative action is subject to strict scrutiny, we had to undertake testing, we had to undertake studies with respect to whether in fact there was a compelling governmental interest. And if the racial preference has to be narrowly tailored, then we have to undertake studies that can tell us exactly how to target an affirmative action program. And that has been the standard, and I would suggest until recently, we can extend the Harvard case, and I think we get some new standards coming out of that. Adoran Contractors versus Pena, 1995, follows the Croson case. It extends that standard that we saw in Croson to the federal government. The Croson standard applied to state governments and state subdivisions. Adoran goes to the federal government. So we have at the Supreme Court level a certain hostility to affirmative action, and you can see it in all areas except education, where the standard had been the Powell standard. And the Powell standard, in fact, is adopted explicitly by the United States Supreme Court in 2003 in the Grutter and Gratz cases involving affirmative action at the University of Michigan's law school and its undergraduate school as well. And there, a narrow majority of the court, over strenuous dissents, confirmed Powell's position in Bakke. So we have really a two-headed beast here. On the one hand, we have a certain questioning of affirmative action, a desire to inquire into it deeply, the sort of testing that the Croson case demands for affirmative action outside of the educational sphere is intense, and a whole industry grows up to justify affirmative action where it can be justified. On the other hand, there is affirmative action in education where the diversity standard continues to rule until Students for Fair Admissions versus Harvard. Now, on one level, the result in the Harvard case is absolutely no surprise. The groundwork had been laid, and you can see the groundwork in the various affirmative action cases outside of the educational sphere. You can see the groundwork having been laid, in particular by dissenting opinions by Justice Thomas, who is an enemy of affirmative action for reasons that he explains quite well, even though I might not agree with them. He is an enemy of affirmative action. He brought back in opinion after opinion after opinion his view that racial preferences of all kinds, even those intended to advance racial groups which had been the subject of racial discrimination before, of all kinds, are presumptively unconstitutional. They're subject to strict scrutiny, and not the kind of strict scrutiny where we can do it if we really work our way through it enough, but strict in theory, fatal in fact. Now, the Harvard case provides the Trump administration a basis on which to challenge the very existence, not simply of racial preferences in admissions or hiring, but the very existence of DEI, let's say the words diversity, equity,
and
inclusion, of DEI programs, a basis to challenge the creation of safe spaces on campus for minorities. For those of us who attended college, I'm gonna make a confession here. I started college, what is it, 1973? What is that, 50? A long time ago. And my university had just begun, had just opened up an Afro-American Cultural Center, where those of us who were black found programs that catered to us. There was safety and comfort in numbers. The Trump administration has called such spaces unconstitutional. It has called into question special funding for minorities on campuses, as in scholarships. It has called into question racial requirements for any particular program. For example, we want to have a program on racism. It might be useful for us to have both white people and black people. If we want to have a forum on religious discrimination, we might want to have some Jews and some Christians and some Muslims. But the Trump administration's view is that such racial designations are to be questioned. I was talking about this with Professor Samuels. I think there is reason for us to fear. It is very clear right now that the Trump administration is looking askance at the funding of HBCUs. There is special funding for HBCUs intended to make up for the fact that states have traditionally not funded them well. This sort of funding is in question. They haven't done anything about it. They've talked about it a little bit, but I think this is on the horizon for us. So the first thing I wanted to talk about was affirmative action. The case is 2 years old, but it has present effects. And the present effects are given, I think, much greater resonance by the political position of the Trump administration. The second thing I wanted to talk about here was voting rights. Voting rights redistricting, or shall we use its evil-sounding equivalent, gerrymandering, and the Voting Rights Act. So this topic is in the news today. Have the Democratic legislators in Texas come back home yet? I don't think they have. And why not? That's because Texas wants to gerrymander the state. They want to redistrict the state in order to advantage the party in power, which happens to be the Republican Party. Republicans are talking about the same thing in other states, Ohio and Florida. And Democrats are talking about it now as well in California, New York, and Illinois. Is it the war of all against all? Well, maybe yes, maybe no. The future will decide that. But what gerrymandering certainly means is that politicians, elected politicians in legislatures, are able effectively to pick their own voters. And the question is, do we have limits on this? They're able to pick their own voters by the process of what we call cracking and packing, right? Cracking, dividing a demonstrable group of voters into more than one voting district in order to lessen their political influence. Packing, stuffing demonstrable groups into districts such that they hold power. by a combination of cracking and packing, one can minimize the political power of political opponents or the other race, and one can maximize the political power of one's own political party or one's own race. Now the question is, what can we do about this? Can this be challenged? And the answer is both yes and no. We have to go back to a case from 2019, Rucho versus Common Cause, which held that redistricting is not ordinarily subject to federal judicial review. This is, to use a term that we would use in law school, a political question. Such cases are non-justiciable because there are no legal standards, the court has said. All we have are political standards that govern redistricting. Now, under Rucho then, no matter how bad a redistricting looks, how unfair it is, it leaves persons of a minority political party vulnerable to the political machinations of the majority party who want to win at all costs. Even if that means that legislatures and legislative bodies that are meant to represent people are not representative of the people. Legislatures cannot discriminate racially, however. That would violate both the 14th Amendment and the 15th Amendment and the Voting Rights Act passed in 1965. How should we put it? The Voting Rights Act passed in 1965 makes that standard operational. Now, the early cases, and I'm going back to 1966 with South Carolina versus Katzenbach, and 1980 with City of Rome versus the United States. These early cases, in many ways, are easy cases because it is as though the court is saying, we know y'all are racist, and Congress can put these restrictions in. There is very little questioning of congressional reasoning, not substantive. Well, it's substantive, but there is very little in the way of questioning of congressional reasoning. And this is going to be the case, more or less, all the way until Shelby County versus Holder, the 2013 case that followed a case that most never really heard about. It was called Northwest Austin Municipal Utility District Number 1 versus Holder. That was 2009. 2009, as you will recall, is the first year of the Obama administration. Shelby County versus Holder ended the pre-clearance formula of the Voting Rights Act under Section 4. And I'm going to move back here just a second because I misstated something. Shelby County ended the pre-clearance formula. It was declared to be unconstitutional. Northwest Austin Municipal Utility District, on the other hand, was a case in which the court determined to do nothing, but in which Justice Thomas wrote a devastating concurrence. The majority opinion, if I recall right, by Justice Roberts, suggested that the pre-clearance formula was to be constitutionally questioned. In other words, this is an indication to the litigating public that it is willing to look at this issue and look at it very, very closely in the future. And Shelby County versus Holder follows that case, and it ends the preclearance formula. And why? Because in the court's view, there was insufficient evidence of continued racism in voting, voting and election laws in the South and in covered districts. Now, I want to almost quote Justice Ginsburg here, who said that's like saying, if you're not getting wet because you have an umbrella, that doesn't mean that you don't need an umbrella anymore. So this dovetails with our situation here in Louisiana. I want you to think about our former representative in Congress, Garrett Graves, and I want you to think of him as a victim of what? Well, first, a vendetta by Jeff Landry, and secondly, of a desire to protect Mike Johnson, Speaker Mike Johnson. How many here like having a speaker from the state of Louisiana? I'm not saying you like this speaker. How many of us like the idea of having a speaker from the state of Louisiana? I like that idea. And they wanted to protect him, and they wanted to protect Steve Scalise, who's the second ranking Republican in the House of Representatives. This is power, people. They wanted to protect Johnson and Scalise and Julia Letlow. And if the cost was letting Garrett Graves go, well, so be that, especially since he was not the governor's friend. So he's the victim, let's say the word, it's not a dirty word, of politics, but he is also the victim of Section 2 of the Voting Rights Act, which commands that lawmakers consider race enough to ensure that black voters have fair representation. I am literally out of time, so I'm going to cheat just a little bit and say that this, of course, relates to Louisiana versus Calais, which the court put off deciding in this last term. Unless this is a racial problem, Rucho says that the court isn't going to touch this. But Louisiana versus Calais calls into question whether the motivation behind the districting here was simply to get Garrett Graves, or instead for black people and their political allies to elect a Cleo Fields. If this is the predominant motivation, this is going to violate the 14th and 15th Amendments. If not, then not, and Rucho obtains, unless, and here's the danger, unless Section 2 is unconstitutional. Because the court has asked questions on re-argument. It has asked the lawyers to address the question of whether the command to consider race is at odds with the Equal Protection Clause. So it is my time to go. The pastor here is looking very uncomfortable, and he's about to drag me from the podium, so I'm going to sit down.
Okay. I thought that was a big transition here. All right. Let's see. Just, how do you do this now? Foot on. Okay. Okay. There we go. Here we go. Well, whatever. All right. Thing. Dating teacher in graduate school. Good afternoon. First of all, I want to, like my colleagues, I want to thank Wesley for hosting this forum. Thank you, Pastor, for and for the invitation, for Judge Pitcher, for the call and the opportunity to be a part of this esteemed panel here. I've been asked to talk about this from a political standpoint, and I dabble a little bit in law a little bit too. I'm gonna have to, there may be some references to that as well. Too often, the metaphor for this time, or I'm sorry, the adjective to describe the politics of the time is to talk about how, quote unquote, unprecedented a lot of what's happening. And it's very tempting to talk about a lot of this as unprecedented, you know, given who is occupying the White House, whether you want to call them 45, whether you want to call them 47. You know, we can tick off a number of things that this president and this administration has done that distinguish him not just from even from other Republicans, and just in terms of the very personal ways in which he attacks his political opponents, where he attacks private individuals, how he goes after judges, the unwillingness to accept his electoral defeat in 2020, and the mob that was assembled ultimately on January 6th, after all other methods of trying to reverse the outcome had failed, and that's just his first term. And so having after all of that to get reelected, and so now he basically feels like he has no guardrails, and then when you see what the Republican Party is doing, how they, this idea that we grew up with, this idea that's supposed to be this separation of powers and checks and balances, when we're seeing the Congress of the United States literally laying down. We're seeing the Congress of the United States literally giving up its power. I mean, the power of the purse. One of the signature powers of the Congress is that the Congress is just sitting there and allowing the president, to take power after power after power from it, and sometimes the lower courts have at least tried to stop him, but then the Supreme Court sometimes allows the president to do. Sometimes has been allowing the president to do whatever he wants. And some of the ways in which, quite frankly, we're being embarrassed on the international stage. The president went to Saudi Arabia, went to the Arab world, and he was willing to take. I don't see any problem with taking a $400 million gift from Bahrain. He actually seemed to mock the idea of the United States going around the world, telling people how to live, lecturing them about human rights. We just had a summit or a dummit with Vladimir Putin. I don't know what that was. That was not a press conference. There was no news. It was no news, and they didn't answer any questions. I mean, so this is not a press conference. Press conference. But here's the idea. A friend of mine posted this on Facebook this morning. Someone breaks into your house. You call the police. When the police arrive, instead of apprehending the intruder, we allow the intruder to take some of your valuables with them and give them a key to your front door on the way out. And that's called a peace deal. And essentially that's what Trump is probably trying to do to Ukraine. You know, in other words, we're actually meeting with or rewarding the aggressor and acting like Ukraine is the one who's the obstacle to peace. So I mean, so a lot of this, a lot of what's happening, you know, what stuff we see ICE doing, it feels unprecedented in a lot of ways. But I want to suggest to you that a lot of this is not new. I think we need some of this is unprecedented in some way, but there's a deja vu character to a lot of what's happening. You see, in many ways, Donald Trump and the Republicans are giving the world and this country the treatment that they have always given black people. You know, so some of what's happening, you know, it's happening. This might be news to Harvard or Columbia. They're not used to being treated like this. You know what it is. But black people are very used to a lot of what's happening. Every time in American history, when black people have made progress or perceived to be making too much progress. In the United States, in America, there has always been a predictable reaction to that. There's always been a backlash, a pushback against every time when black people appear to be making progress or making too much progress. And that is the pattern of American history. After the American Revolution, for example, when actually some people were having tinges of conscience about, being the people who were advocating for a revolution about human rights and human dignity and holding slaves. And, when you start to see some states began to slowly abolish slavery, questions about legalizing the slave trade, free black communities starting to emerge in some of these places. There was a backlash against that. We got to make it harder for people to emancipate their slaves. We're going to have to limit the rights of free people of color. There were people of color who actually had the right to vote. We got to take that away. We saw this same reaction against emancipation, against at the end of the Civil War, as black people now have certain rights. The 13th, 14th, and 15th Amendments, black people are running for office, black people are starting businesses, black people are buying land, trying to move on, and there is a reaction against that. The very idea that the same people who were enslaved just a few minutes ago could now be the equals, that is an anathema to Southern white. And so they use racial violence to destroy Reconstruction. They basically engage in guerrilla warfare. I mean, we may have lost the war on the battlefield in many ways, but the fighting isn't over. Louisiana, by the way, played a very significant role in the destruction of Reconstruction. It was in Louisiana where we had the Colfax massacre. And out of that case came the United States versus the Cruikshank, in which the United States Supreme Court undermines the attempt by the U.S. Justice Department to hold at least a few of the ringleaders accountable. In fact, effectively, this case, the precedent of this case is that black people can be killed with impunity. Just in time for the 1877 presidential election, which will be controversial. If you thought the 2000 election was a cliffhanger, 1876 was worse than that. You got 4 states, Louisiana being one of those, in which the electoral votes are in dispute. You got racial violence, you got voter intimidation. All this is to basically to steal the election. Ultimately, this leads to the Great Compromise, or the 1877 Compromise, by which troops are withdrawn from the South. U.S. federal troops, and black people are now, their fate is now in the loving hands of the same people who had enslaved them in the first place. We're going to allow southern states to govern their affairs. That ultimately leads to Plessy versus Ferguson, which also came out of the state of Louisiana that set the separate but equal. It was Louisiana that came up with the grandfather clause. That would the grandfather clause is this odious restriction that basically said that if your grandfather had been able to vote prior to 1867, that date was chosen deliberately because that was 1867 was when the U.S. Army began to register formerly enslaved people to vote. So, but if your grandfather was able to vote prior to that, you can vote as well. That was actually designed as a carve-out for some of the poor whites who were being discriminated against and denied the right to vote. But if your grandfather could vote for that, then you could too. We're going to prevent some poor whites from voting too. We're not afraid of doing that because sometimes some poor white folks can't be trusted to vote the right way. So we saw that Louisiana. So Louisiana has a long history of racial hierarchy. Almost every advance has come about because black people have forced it, or there has been some kind of failed intervention. We fast forward. We have the highest per capita number of black elected judges in Louisiana, not because Louisiana is so enlightened, but because black people had to sue the state of Louisiana in order for that to happen. Some young lawyers like Janice Clark and Ernest Johnson, as because of their lawsuits that we have so many black judges in the state. That would not have happened had there not been some kind of federal intervention. Louisiana is our ways to turn the form. We are now at the center of this struggle about voting rights. This case, Louisiana versus Calais, Louisiana, where the voting rights section itself is now under attack. What's being argued here is that the very consideration of race is itself racist and violates the Constitution. It violates the Equal Protection Clause of the Constitution. In other words, what they're trying to do is really to turn the Constitution on its head, to turn the Equal Protection Clause on its head. The same clauses, the same amendments that were designed to remedy the slavery, segregation, discrimination, are now being used to actually and being weaponized against the very people whom they were intended to protect. But again, that is also not new. It was actually the Supreme Court played a leading role in nullifying the effects of the 13th and 14th and 15th Amendments through a variety of decisions. Again, starting out in Louisiana with the Slaughterhouse case, all the way up to Plessy. Meanwhile, while the Supreme Court was making the 13th and 14th and 15th Amendments effectively dead letters, it was using these same 14th Amendment to give rights to corporations, to come up with rights out of whole cloth, things that were not even discussed in the Reconstruction debates in Congress. Between 1868 and 1912, the Supreme Court considered 28 cases during this time period dealing with the 14th Amendment as it relates to the civil rights of African Americans. And in most of those cases, they actually ruled against black people. Okay. Meanwhile, in that same period, the court heard over 300 cases that used the 14th Amendment in one form or another to advance the rights of corporations, particularly the rights of corporations to be exempt from regulations from states and local governments, and sometimes the federal government that were trying to limit their power. And what we're seeing is a resurgence of that same kinds of jurisprudence, where we're where on one hand we're making it harder to use the laws that were supposedly designed to remedy systemic discrimination. At the same time, we're expanding the rights of others. We're giving rights to the corporations. That is where we are right now, and that's why what's happening right now is so dangerous. I want to end on this, and I think the thing in Ukraine is a very good example of how dangerous this period is and what it has to do with black people. See, typically, historically, the fact that America is a powerful idea and that we have been able to appeal to this idea of America as a powerful idea, and the idea that America stands for things in the world, as a way of saying, look, you say this, you say you believe this, you go around the world proclaiming this, but you're not living it out here. Black people have appealed to the same values in the Declaration of Independence and the Constitution and America's role in the world to say that we should be consistent with that at home. And also because it's such a powerful idea, it's not just black people, but many people of all races have said, you know what? We believe that too. And because of that, we've been able to, in many cases, to able to achieve multiracial coalitions of many white Americans who said that no one is free unless all people are free. Mm-hmm. Okay? What is at stake now when you see what they're doing? The Trump administration is not even pretending anymore that America stands for anything in the world. And what's dangerous is that idea is allowed to consolidate. If we get to the point where we really don't stand for anything anymore, that you can't even appeal to that ideal anymore. If that day comes, and we have a role to play in making sure that day does not come, but if that day comes, communities of color, the most disadvantaged among us, are in more danger than we have ever been. I'm gonna stop there.
I think he come back.
Dr. McClanahan, we have you later on in the program, and then you can perhaps share at that particular point in time. We began a little bit late. I'm going to ask if you would allow for maybe 20 more minutes for us to have a robust conversation, a forum, if you will, with the speakers present. And then after that, we will open up questions from the floor. And then we will proceed with the program hearing from Dr. McClanahan and our very own councilwoman for District 10. So I'm going to ask the presenters to come and take your seats, and then Judge Pitchford and I will engage them with some peppered questions, and then we will open up to the audience to ask some questions. If you need to stand up and stretch, feel free to do so, but don't leave, because I know if I left, I wouldn't come back, but we want you back, all right? So as if you need to stretch or what have you, but we want to make sure that we move forward in some way. So let us jump right into this forum period, and then we want to open up questions from the floor. I'll defer to Judge Pitchford at this time, and then I'll ask some questions of my own.
Let me make sure I got this right. Here we go. Well, again, I want to thank the panelists for your presentations. Everything that you guys are talking about is quite relevant. Having grown up in the 60s and 70s, and then all of a sudden, here it is, 2025, and to see some of the things that's coming down out of the Supreme Court, has really given me cause to pause. So when Pastor Richardson called me and mentioned that he wanted to do something of this nature, I really got on it, because being that child of the 60s, I'm concerned. I'm concerned about where we're heading, and especially with the Calais case. With Calais has implications not only for Louisiana, but for the whole South. So would you guys talk about what Calais can really do if the court comes down the wrong way?
Calais, I think our mics are on. Calais undermines the Voting Rights Act entirely. We no longer have preclearance because we no longer have a valid preclearance formula. At no time since 2009 have we had unified control, Democrats in the White House and in both houses of Congress, except under the Obama administration, when the administration put all of its political capital into the Affordable Care Act. And as it stands right now, we have no preclearance formula, and let's tell the truth, because Republicans do not want one. If we lose, if the wrong side loses on the Calais case, this has implications not only for congressional redistricting, but also for redistricting at legislative levels, at the state and the local level as well. Just 2 days ago, this is Saturday, right? Thursday, the Fifth Circuit came down with a case saying that our redistricting plan for the Louisiana legislature violated Section 2. That case is lost if Calais goes the wrong way.
And I would go further to say that in some ways it kind of harkens back to a lot of the jurisprudence of the 1890s and in the 1900s, where you have a right to vote in theory, subject to the limitations that states may impose. And that seems to be increasingly the world that they're walking toward. And the fear of the lack of a quote-unquote white majority. This also, there's nothing new, by the way. This was the same fear you had in the South. You know, when slavery ended, many of these states were majority black. And so democracy means that if practiced, that means that we have to share power with black people. America has shown its willingness to destroy democracy itself if it means sharing power with black folks.
It's ironic that a case that is pending before the Supreme Court dealing with voting exists, and I think underscores the importance of voting. Voting has consequences. And I take you back all the way to 2016 when some classifications, distinctions of people, whether it be one issue, two issue voters, or maybe some argue that we're not ready for a female president. Whatever the case may be, we were blessed or cursed, depending upon your viewpoint, with Donald Trump in his initial term. Probably one of the most critical terms as it relates to the Supreme Court, because he appointed not one, not two, but 3 justices. And so it's not lost on me the irony of a case dealing with voting and the importance of voting to underscore that we must, without fail, exercise our right to vote. And I would go so far as to say, be mindful of not being a one-issue voter or a 2-issue voter. There is never a perfect person who you will get to sit in any seat that deals in government, be it the mayor, city council, the dog catcher, all the way up to the office of the President of the United States. You have to, though, avail yourself to voting to avoid these types of circumstances that we find ourselves in as a country.
I think it's been well said, and I don't want to keep hammering the same point home, but I do believe of particular importance, again, as a Christian, in understanding what the true definition of Christianity is, and not allow ourselves to be controlled and manipulated by segments of the political arena that have been able to manipulate many people in our community based upon our religious beliefs, tied to whether you're pro-life, whether you're pro-choice, how you feel about other hot-button issues, whether it be gun law, gun control, etc. As Professor Thrower mentions, we have to think about the big picture and not just say, I cannot vote for this person because she is a woman, because of my cheap beliefs, or I cannot vote because this person favors the right of a woman to choose, because so many other issues are an important component in who you choose to serve in, as you mentioned, any office. Of particular import, though, the office of the president.
I'm going to defer my time to the audience that are present here today. If there are any questions that may just come up to the, thank you, and be sure to speak into the mic because the people online, and this is being recorded and will be cast on YouTube, they need to hear you, okay?
Good evening. I appreciate hello?
There it is. There it is.
Hello? Thank you. My name is Cornelius Troy Hall. I am an SULC graduate. I'm a former student of Dr. Samuel. I am a church member of Chancellor Pitcher, and I actually took Professor Diamond's wife, Frida Sellers Diamonds, taught me Fair J when I was in law school. Right now, I currently serve as a junior editor and contributing writer for the Baton Rouge Lawyer magazine, writing on issues dealing with legislative updates and legal case reviews, focusing on gerrymandering, redistricting, and constitutional violations of the Voting Rights Act as it ties into both of those issues. I've done some articles on the new CD6, Congressional District Number 2, and I've done some articles on the jungle primary restructuring here in the state of Louisiana. And my question dealing specifically with the Calais versus Landry. Number one, how do you think the Supreme Court in the end will ultimately rule? Do you think it would be a situation such as the Supreme Court ruled in Allen versus Milligan, where they basically held that restructuring districts to dilute, trim down the effect of African American voting rights strength is unconstitutional via the Voting Rights Act, and also in particular with the Nan versus Audubon case, which Professor Diamond was talking about? Is that something you think will make it to the Supreme Court? And the last one is, in the Calais versus Landry case, when the Supreme Court, as you know, basically said we can go on with the 2nd Congressional District, basically placing a halt on going away with that legislative decision by the Louisiana State Legislature. Do you agree with Justice Jackson in her take on the Purcell principle? In other words, is it something that the court could have held off on, given the state more time, or do you think it was something that needed to be done? Because if it hadn't been done, you may not have Congressman Fields in office right now.
Okay, thank you so much. I'll let them kind of tackle how they wish to tackle it.
One thing I will say about this case, and that is, it is very problematic in many ways that the court is actually re-arguing this case in the first place. Simply because, in many ways, the Louisiana case is the Alabama case. The Allen was the Milligan case. The court only 2 years before, and in fact, what Louisiana Republicans did is even more egregious conduct than what the Alabama Republicans did that you just held to be unconstitutional. And so Republicans and conservatives who have lionized notions of stare decisis, and things like this, this is not a decision that you made 20 years ago or 30 years ago. It's 2 years ago. This is the same case. Louisiana claimed it was the same case. That is until Alabama lost. Then they claimed, well, our case is different than Alabama. When they thought the Supreme Court was going to rule in Alabama's favor. So that by itself gives us pause when the answer to this is exactly, you should rule in this case exactly the way you rule in Alabama. And so the fact that they're even considering the questions that they're raising means that they're swinging for the conservatives. They're swinging for the fences. They're coming for the entire Voting Rights Act. And there are probably at least 3 people that we can count on. Thomas, Alito, probably Gorsuch. Actually, Judge John Roberts has been an opponent of the Voting Rights Act at least since he was a staffer in the Justice Department under Ronald Reagan. So that's 3, probably 4 votes right there. It's going to come down to how Amy Coney Barrett votes and Brett Kavanaugh votes, and I don't like our future to be in the hands of those 2.
Does anybody else want to address that, or we can go on to the next question?
I will simply say I agree with that count.
And I will also just, on the question of stare decisis, clearly we see that this board is not at all concerned about respecting long-standing precedent. So certainly respecting a decision from just a few short years, I don't think, you know, they gave a lot of lip service in Dobbs and in Kennedy, but nevertheless still overturned long-standing precedent, so.
We're going to take one more question, and then we're going to close things up. Go ahead.
How y'all doing? Xavier Chapman, 2L, Southern University Law Center. Thank y'all for having this conversation. It's very important. Based off this conversation and what I've observed is happening across the country, because we didn't vote, we are slowly going back to times that we don't walk so far to come from. My question to you all is, what can we as law students and prospective law students do in order to put our hands on the fight that's already ensuing? Because we ain't made it out of August yet. We got 3 more years to go. How do we fight?
Well, you know, I'm the former chancellor at Southern University Law Center. And one of the things that I tried to do when I was there was to reinstate the Civil Rights Institute. Too many times that I mentioned this earlier, you know, students come to law school with visions of sugar plums dancing through their hair. And they look at, you know, well, I want to be a transactional lawyer. I want to be, you know, this great criminal lawyer who can stand up in court, you know, and make great orations before the judge and jury. But with what we see going on right now, you need to take those constitutional law seriously, look at from whence we've come, and as Judge, who I mentioned earlier from Florida, Alcee Hastings said, prepare yourself to be the best lawyer you can be to be able to tackle some of these same questions that we're talking about right now. Prepare. And so within the confines of the law center and the students, be involved with some of the programs there that will in turn help you to be able to do some of the stuff in the civil rights arena, because we need soldiers to fight.
Thank you so much. We're going to wrap this up so we can, in the interest of time, hear from our council person. Okay, we'll take one more, and then we'll close up, okay?
Let me say, you know, the problems we have are not technical, they're not legal, they're not political, they're not religious, they're moral problems. When people, I believe Reverend Richardson talked about the fact that might doesn't make right, but we're actually in a situation where we're doing nothing in our society to establish that right makes might. When
Brother, we got to ask you your question.
Professor Samuels, I'll get this quickly. When Professor Samuels suggested that they're willing to throw away democracy in order to to make certain that blacks don't have any power, that's because the definition of democracy right now is incompatible with power. When you get Dr. King, I just heard a fellow today, he was quoting Tillich in this idea that about power and love, and Dr. King talking about power is reckless and abusive, and love is sentimental and anemic. But the problem is that these people, these theologians, don't understand the difference between power and love. And so I want to suggest to you that what we have to do is change the paradigm in our society. You saw it with Tom Sawyer. All the little boys were getting ready to go fishing, and Tom Sawyer had he was being punished to have to whitewash the fence. But because Tom Sawyer demonstrated to the little boys that there was something he was doing more important than what they were getting to do, that caused them to pay attention. Right now, the fact that, you know, you made the point that the changes in this country have come because of the moral example of black people. The problem is that the moral example that black people have right now is just as neoliberal, just as materialist as the worst kind of examples that are coming from MAGA. So I would just say to you, if you remember Maya Angelou, she said that when you know better, then you can do better. This society, when you got a society that has a $30 trillion economy, you got individuals with $300 and some billion worth of wealth competing to be the first trillionaire, this is not anything they need. Obviously, this is just some kind of addictive behavior. So let me just put it succinctly.
Yes.
What I would suggest is that you are our leaders. What can you do to essentially change the conversation away from these narrow kind of technical discussions within these narrow domains that people have, to this larger moral discussion, not a religious discussion. I don't care about you being no Muslim or no Catholic or no whatever, but a moral discussion about what's coming from your heart as opposed to what's coming from your mind.
Thank you so much. We're going to move now and I'm going to thanks the panel, and we're going to move now to our calls to action. And I know that the councilwoman may need to go, so I'm going to give her a chance to speak, and then we'll go into our calls to action 1 and 2. So please, let's give our councilwoman a chance to speak, and then we'll move into our calls to action. Thank you.
Thank you. And I say it's evening time, good evening right now. And I'm grateful to you, Pastor Richardson, for what you're doing here at Wesley. And as I've said before, you do what many of the other churches are afraid to do, and that is to have these kind of conversations. And then, as you mentioned earlier, to follow up, to assess what has transpired and how, if it needs to be or can be perfected. So you're to be, yes, I'm grateful for that. And the Honorable Judge Picture, I thank you for reaching out to me, little old me, and asking me to come and just share and be a part of this. You know, I've heard several words here today, you know, but the big word is community. This is a community forum, everyone. And then when the gentleman said, what is it that you all can do, the first, and I'm asked that all the time, but what I always ask is what can each one of us do? And then be responsible for the doing. And as I sat there, panel, and heard all of you, I said, I feel like I'm in law school here, and what will my LSAT be? And I believe be a little low. So I've learned some stuff here today and look forward to returning. But I just want to say today that we need to keep in mind about community and what it is that we need to do, not just coming to forums, but after we come, after we get information, then going out and doing something with the information. I kept hearing the word voting, and that ought to strike every last one of us that's in here, because that's a hole that we have in Baton Rouge. That's a hole that we have in the black community. That's a big hole. And a lot of folk feel like, vote for what? Then I say to them, don't vote and that's what you get. What? And so I stand here and just, I'm grateful to hear about all and look forward to the follow-up. See, it's important to have something, but you gotta have follow-up. And it has to be continuously done in order that it can make a difference. And so I am grateful. I even think about all of the redistricting that's going on, then the purpose behind it, the upcoming judge seat there it is that they've spread it, how far that goes out. And this upcoming judge election in October is really just filling in a judge seat. But they've redistricted you all. And so you all, we've got to be about the business of, and it's good to hear all of this, you know, as the old folk would say, highfalutin talk. But the bottom line is we've got to get out and get our people to understand the importance of voting and get to the poll. And so I am grateful, and I think I have a little homework, because I'm going to go and read some of this stuff here that I've heard here today from you all, and I appreciate this opportunity for sure. Thank you.
Let us have our two calls, and then we will have our benediction. I'm going to ask for, thank you, Dr. McClanahan, to come in, and then we'll have our second call to action by our head of outreach.
Good afternoon, everyone. I'm not going to hold you long. I want to thank Pastor and the panelists for putting this together. Judge Pitcher calls me, and you know he's one of my mentors, so I was going to run. But all of you for being here, because I think it's important. A lot of times we see on television what's going on in the news, but this is firsthand knowledge and firsthand experience. We have Dr. Press Robinson, who's one of the plaintiffs in the Calais case. He was very, very instrumental in moving that case along. And so, you know, my call to you is my call when I started this redistricting process is that we must be partakers in it. You know, we don't need to be looking at it from the outside. We need to be at the table. You know, I told the legislature, if you redistrict right, I'm going to sue you. I said, we have the law, the lawyers, and we have the Lord. That's a winning combination if I've ever seen one. Guess what? We've been winning. We won last Thursday. We won based on the Alabama case before the Supreme Court. I was there in the arguments. We're winning. I believe we're going to win come October the 15th when we go up to hear the arguments again. Because right is right. But you have to participate. We talk about voting because you don't go to the legislature. They're passing laws that will bring impediments to your ability to go to the polls and vote. They've passed laws that would impede your ability to go to the polls and vote. One that say that you can't, absentee ballot, used to, you know, if you're going out of town, or if you're elderly, you normally have somebody to sign as a witness to your absentee ballot. Can no longer do that. It has to be one person, it has to be a relative. Somebody should go sign them all and just drop them all off. That can no longer happen. There's no longer an independent party in Louisiana. Nancy Landry says, oh, nope. Either DRR. I want it to be something else. I want to be anything. But the state of Louisiana says that's no longer the case. So you have to talk about voting and the impediments and the things that's going to get you there all the time. We have family reunions, talk about it. We have tailgating, talk about it. There's an app on your phone that says I can determine who voted. So I'm going to put that on my wife. If she ain't voted, I'm going to call a lawyer. She needs to go. My kids don't vote, I'm going to disinherit them. That's serious. Because if you don't have the ability to vote, which is the cornerstone of democracy, what do you have then? Democracy says that I can elect the candidate of my choice, whom I want to, right? But if they limit that, you're no longer in a democratic society. And it's going to be hard pressed. The other thing that you must do, there are some things that you have to do besides vote. I wear a vote shirt every day. But you must host candidates' forums. Because whenever the Supreme Court rules in our favor, I said rules in our favor, y'all heard that right. That means there's going to be opportunities for candidates to run and fill those positions. So that means with the Narron case, so we're entitled to at least 6 state representative seats, at least 2 or 3 senatorial seats, right? We want those candidates to be persons that look just like us. But if you don't go, if you don't hold the candidates form and go select a person to run, they won't look like us. Those seats are for us. Because I do believe if somebody looks like me can appreciate where I'm coming from and where I'm what? Headed. All right. The other thing is that we need to serve on juries. Bam. How many of y'all run when y'all get that letter in the mail? Oh, Judge, I can't serve. My children are sick. You ain't got your children grown. Don't even live with you. You must serve on the grand jury, petty jury. A couple of weeks ago, I spoke to Professor Bell had the exonerate cases men that were there at the library. About 8 guys served about 600 years in prison for crimes they did not commit. Professor would tell you that, Sam would tell you that the 10-2 jury came about because they realized that if I let blacks serve on the jury, they're going to be sympathetic to the black man and get him off. Those guys, I can't speak for a certainty, but if we were serving on jurors, they might have served that time. So we must adhere to our responsibility to serve. So tell your family to go serve. When they call me, Mr. McClain, how can I get out serving jury? I'll go close the door, hang the phone up. We need you to serve. You must serve. Our freedom depends on you going to the polls to vote, telling somebody who needs to go run for an office. You can know who's a good guy who's going to run. Say, I need you to run and support them with your money because freedom ain't free. Running for an office is not cheap. You need to support them with your money, and you need to tell them and your friends, go serve on these grand jury and petty juries, and God will take care of the rest. Thank you.
If I can just chime in a little bit, you know, I was on the 19th Judicial District Court for a number of years, and one of the things I also used to do was encourage people to serve on juries. Because if you don't serve, then and a decision is made, you don't have a right to complain because you did not want to serve yourself. But my point is not serve because being black, you will in turn let a black person off. It's about being able to share your life experiences with other people who may not have had the same kind of experiences to understand and interpret the quality of the information that's being presented to the jury. You know, so I would tell you, black people vote folks guilty too, you know. And, but I just want everybody to understand you're not serving because you want to get somebody off. You're serving because you're sharing life experiences in order to help other people understand, you know, what the evidence is and so forth.
Good evening, everyone. I am Bree Russell. I'm the lead chair here at Wesley for outreach. So I do want to thank everybody that stayed. I know this is Saturday. I'm hungry. And so inside your program, there's a impact card. So number one, so I'm called number 2, right? So right now, with you being here, your action, you still have passion to see change. That's why you're sitting here. That's why you're listening, right? This is your way of showing the action. If you know Pastor JC, he is very follow up. We're going to do this again, and the way that we keep having these questions and panels are collaborative efforts and ways to contact you to get in. So if you can fill this out, I will be at the back of the church to collect, or if not, if you don't see me or I'm talking, there is a gold charger on the back table. You can just put your card there. And my prayer for you today is that we all leave here knowing that silence does nothing, but action changes everything. Thanks.
All right, if we can all stand for our benediction, and we'll come down here because we want to make sure that everybody understands. This is a good first step. Time has been long spent, but it has been well spent. And let's give our panelists and let's give our co-facilitator a hand. Thank you, thank you, thank you, thank you, thank you so much for giving up your time behind the scenes, and hopefully we can continue this process of informing everyone. Those online, thank you so much, whether or not you're watching on delay or presently, for your attention as well. There's a benediction that I am going to give. It was given by Bishop Woody White in 1996 at a United Methodist conference in Denver, Colorado, and that will be our benediction. And then when you leave, say hello and say something nice to somebody and share something good, all right? With that said, I'm going to also repeat, I believe in evaluation, so you know who you are. We're going to be meeting in the Blue Room to see how we can do better and what we did well, okay? With that said, let us have our benediction. And now, may the Lord torment you. May the Lord keep before you the faces of the hungry, the lonely, the rejected, and the despised. May the Lord afflict you with pain for the hurt, the wounded, the oppressed, the abused, the victims of violence. May God grace you with a burning thirst for justice and righteousness. May the Lord give you courage and strength and compassion to make ours a better world, make our community a better community, and make our nation a better nation. To make your community a better community, to make your church a better church. And may you do your best to make it so. And after you have done all your best, may the Lord grant you peace. Amen. Thank you, everyone. Bye-bye.
I would love to have a book signed here at your church.